Good afternoon, everyone. Today we're going to spend the next 90 minutes examining one of the most recent developments in First Amendment jurisprudence, a case that touches on something most of us encounter every single day but rarely think about from a constitutional perspective. We're talking about vanity license plates and the Supreme Court's decision just this morning to decline hearing an appeal in a case that could have reshaped how we understand the boundaries between government speech and individual expression. Let me start by giving you the basic facts. On December 8, 2025, the United States Supreme Court declined to hear the appeal of Leah Gilliam, a Nashville resident who has been fighting for years to have her personalized license plate reinstated. The plate in question read 69PWNDU. For over a decade, Gilliam drove with this plate without any issues whatsoever. She obtained it in 2010, and for 11 years, no one at the Tennessee Department of Revenue raised any concerns. Then in 2021, everything changed. The catalyst for this entire legal saga was remarkably mundane. Someone sent a text message to Justin Moorhead, the Chief of Staff at the Tennessee Department of Revenue, complaining about Gilliam's plate. Based on that single complaint, the state moved to revoke a license plate that had been in active use for more than a decade. The state's reasoning was that the plate violated Tennessee law prohibiting plates that are misleading or offensive to good taste and decency. The department concluded that the plate referred to sexual domination. Gilliam disagreed vehemently with that interpretation. Now, let's talk about what Gilliam says her plate actually means. According to her testimony, PWNDU is Internet and gaming slang. The term pawned, spelled PWNED, emerged from online gaming culture. It means to defeat or dominate an opponent in a video game. It's essentially a deliberately misspelled version of the word owned. So pawned would mean you defeated your opponent, you won the game. As for the number 69, Gilliam has offered two explanations. Initially, she said it was part of her phone number. Later, she explained that she's an astronomy enthusiast and the number refers to 1969, the year of the Apollo 11 moon landing, one of humanity's greatest achievements. Whether you find these explanations convincing or not is almost beside the point for our constitutional analysis today, but they're important to understand the full context of this dispute. The Tennessee Supreme Court ruled against Gilliam in February of 2025, and now the United States Supreme Court has declined to review that decision. So the Tennessee ruling stands. But before we get into what this means going forward, we need to understand the legal framework that governs cases like this. We need to talk about the distinction between government speech and private speech, and we need to examine a critical precedent from 2015. The foundation for understanding this case is Walker v. Texas Division, Sons of Confederate Veterans. This was a 2015 Supreme Court case, decided 5-4, that dealt with specialty license plates in Texas. The Sons of Confederate Veterans wanted to create a specialty plate featuring the Confederate battle flag. Texas refused to approve it. The group sued, arguing that the state's refusal violated their First Amendment rights. But the Supreme Court, in an opinion written by Justice Stephen Breyer, held that specialty license plates are government speech, not private speech. This distinction is absolutely crucial. When the government engages in its own speech, the First Amendment doesn't apply in the same way. The government is allowed to have viewpoints, to express opinions, to choose what messages it wants to convey. Think about it. The government can put up monuments, it can create public service announcements, it can publish reports that reflect particular policy positions. Private citizens can't sue the government for viewpoint discrimination in those contexts because the government is speaking for itself. On the other hand, when the government creates a forum for private speech, even a limited forum, it generally cannot discriminate based on viewpoint. That would violate the First Amendment. So the critical question in cases involving license plates becomes, whose speech is this? Is the license plate conveying a message from the government, or is it conveying a message from the individual vehicle owner? Justice Breyer's majority opinion in Walker identified three factors for determining whether speech should be classified as government speech. First, the history of the medium. License plates have long been used by states to convey government messages, from state mottos to official symbols. Second, public perception. Do members of the public associate the speech with the government or with private individuals? Justice Breyer argued that people viewing a specialty license plate would likely associate it with the state. Third, the extent of government control. Texas maintained direct control over what designs could appear on specialty plates, exercising editorial discretion over proposed designs. Applying these three factors, the court concluded that Texas's specialty license plate designs constituted government speech. Therefore, Texas could refuse the Confederate flag design without violating the First Amendment. This was a controversial decision. Justice Samuel Alito wrote a passionate dissent, warning that the majority's expansive application of the government speech doctrine could threaten free speech. He argued that specialty plates are better understood as limited public forums for private expression, describing them as little mobile billboards on which motorists display their own messages. In Alito's view, the decision gave government officials dangerous discretion to censor speech based on viewpoint. Now, fast forward to the Gilliam case. The Tennessee Supreme Court had to decide whether Walker's reasoning applies not just to specialty plate designs but to the alphanumeric combinations on personalized vanity plates. The Tennessee court concluded that yes, Walker compels the same result for vanity plates. Applying the same three factors, the court found that vanity plates are government speech too. This meant that Tennessee could revoke Gilliam's plate without violating the First Amendment. But here's where things get interesting and where the controversy really intensifies. Most other courts that have considered this specific question have reached the opposite conclusion. Courts in states like California, Rhode Island, Kentucky, and others have held that while vanity plate programs may be subject to reasonable content-based restrictions, the specific messages on vanity plates are private speech, not government speech. These courts have recognized that when an individual pays an additional fee to customize their license plate with their own chosen message, the public perceives that message is coming from the vehicle owner, not from the state. The distinction between specialty plates and vanity plates is not trivial. Specialty plates typically feature a particular design, logo, or image associated with a cause, organization, or institution. Think of plates supporting a university, a charitable cause, or a military branch. The state is offering a menu of pre-approved designs that the state itself has endorsed. Vanity plates are different. The vehicle owner is creating their own unique alphanumeric combination. The state isn't endorsing any particular message. It's simply providing a platform where individuals can express themselves, subject to certain restrictions on profanity, vulgarity, or offensiveness. Gilliam's attorneys made exactly this argument. They pointed out that when someone pays a special fee to create and express their own unique message on a vanity plate, the public reasonably perceives that expression as the car owners, not the government's. After all, no one thinks the state of Tennessee is trying to communicate something about gaming culture or the moon landing by allowing the plate 69PWNDU. The message is clearly personal to Gilliam. Let me read you a key passage from Gilliam's petition to the Supreme Court. At its essence, government speech occurs when the government purposefully expresses a government message through those authorized to speak on its behalf. When a car owner pays a special fee to create and express her own unique message, the public reasonably perceives that expression as the car owners, not the government's. This gets to the heart of the disagreement. Another critical issue in this case is the vagueness and breadth of Tennessee's statute. The law prohibits plates that are offensive to good taste and decency. What does that mean? Who decides what constitutes good taste? These standards are incredibly subjective. What one person finds offensive, another might find innocuous or even humorous. Gilliam's attorneys argued that this gives state officials essentially unbridled discretion to censor speech based on their own personal sensibilities. And the evidence seems to support that concern. During the litigation, Gilliam's attorneys presented evidence that Tennessee had approved numerous other vanity plates with arguably more offensive content. Plates like BLZDEP, IMCMMIN, and 69BOSS were all approved. Even more troubling, plates with explicitly racist content had been approved. The attorneys pointed to plates like 88POWER and COONHTR. 88 is a well-known white supremacist code for Heil Hitler, because H is the eighth letter of the alphabet. The second plate contains a racial slur. Yet these plates were approved while Gilliam's gaming reference was revoked. The Tennessee Supreme Court's response to this evidence was essentially that the department makes mistakes in its review process but retains the authority to revoke plates that are erroneously issued. But this raises serious questions about selective enforcement and arbitrary decision-making. If the standard is so unclear that openly racist plates slip through but a gaming reference gets caught, is the standard really capable of being applied in a principled, viewpoint-neutral manner? This brings us to one of the most compelling arguments in Gilliam's petition, what her attorneys called a dizzying array of censorship across state lines. Because the lower courts have disagreed about whether vanity plates are government or private speech, the same personalized plate that's perfectly legal in one state can be prohibited in another. Gilliam's attorneys pointed out that her plate would be allowed in Maryland, Oregon, Delaware, Rhode Island, Kentucky, California, and Michigan. But it's prohibited in Tennessee, Indiana, and Hawaii. They argued that intervention from the Supreme Court is needed promptly because a car owner's First Amendment speech rights literally change when she crosses state lines. Think about the implications of that for a moment. Imagine you live in Kentucky and you have a vanity plate that you've used for years expressing your personality, your interests, your sense of humor. You move to Tennessee and suddenly that plate is illegal. The government forces you to surrender it. Your constitutional rights have effectively changed based solely on geography. Is that consistent with the First Amendment's guarantee that Congress and by extension state governments through the 14th Amendment shall make no law abridging the freedom of speech? Gilliam's attorneys said this inconsistency demonstrates the need for Supreme Court clarification. Tennessee's response was remarkably blunt. Attorney General Jonathan Skrmetti wrote in his brief opposing Supreme Court review, "This court does not need another license plate case on government speech. One is plenty." In other words, Tennessee argued that Walker already settled this issue and there's no need to revisit it. But did Walker really settle it? Walker dealt with specialty plate designs, not personalized alphanumeric combinations. And as we've discussed, most courts that have carefully examined the distinction have concluded that vanity plates are different from specialty plates in constitutionally significant ways. Now let's consider the broader constitutional principles at stake here. The government speech doctrine exists for good reasons. We don't want the government to be paralyzed in its ability to communicate with the public or to advance policy goals because of First Amendment challenges. If the government wants to create a public health campaign encouraging vaccination, it shouldn't have to give equal platform to anti-vaccination messages. If the government wants to promote recycling, it shouldn't have to promote waste. Government speech allows for effective governance and policy implementation. But the government speech doctrine is also, as the Foundation for Individual Rights and Expression argued in their amicus brief, catnip for government officials. Officials have a strong incentive to characterize speech as government speech because it frees them from any burden under the First Amendment. It gives them unchecked power to control messages, to suppress viewpoints they disagree with, to exercise what amounts to censorship without constitutional accountability. This is why courts need to be careful and skeptical when applying the doctrine, particularly in contexts where the government is facilitating individual expression rather than speaking with one voice. When the government operates a vanity plate program, it's not speaking with one voice. It's facilitating thousands of different voices, each expressing something unique and personal. The government doesn't endorse every message on every vanity plate. It simply provides the platform. In constitutional terms, this looks much more like a limited public forum than like government speech. And in a limited public forum, the government must adhere to viewpoint neutrality. Let me turn now to what this Supreme Court decision means and doesn't mean. By declining to hear Gilliam's appeal, the court has not issued a ruling on the merits. The court hasn't said that the Tennessee Supreme Court was right or wrong. What the court has said is simply that it's not going to review this particular case at this particular time. The Tennessee ruling stands, but it's binding precedent only in Tennessee. Courts in other states are free to disagree, and many have. From a practical perspective, this means that Gilliam loses. She will not get her license plate back, at least not through the federal courts. The Tennessee Supreme Court's determination that her plate violated state law is final. But the larger constitutional question remains unresolved. Different states will continue to have different rules, different interpretations, different outcomes. Vehicle owners will continue to face uncertainty about what they can and cannot put on their plates. Looking at possible outcomes that could have resulted if the court had granted review, there were several scenarios. First, the court could have affirmed the Tennessee Supreme Court and held that vanity plates are indeed government speech under Walker. This would have been a loss for Gilliam specifically, but it would have provided clarity and uniformity across the country. States would have broad authority to restrict vanity plate content based on their own standards of taste and decency. Second, the court could have reversed and held that vanity plates are private speech in a limited public forum. This would have meant that while states can impose reasonable, viewpoint-neutral restrictions, they cannot engage in viewpoint discrimination. Under this outcome, Gilliam likely would have prevailed because the selective enforcement evidence suggests that Tennessee's actions were not viewpoint-neutral. Other vehicle owners with gaming references or cultural expressions on their plates would have gained stronger First Amendment protection. Third, the court could have carved out some middle ground, distinguishing between different types of personalized plates or clarifying when content restrictions are permissible even for private speech. Courts often try to balance competing interests, and there might have been a way to give states some regulatory authority while protecting core expressive interests. Fourth, and this was perhaps the most interesting possibility, the court could have used this case to reconsider or at least clarify Walker itself. Remember, Walker was a 5-4 decision, and it generated a vigorous dissent. The composition of the court has changed since 2015. It's at least theoretically possible that a majority might be willing to narrow Walker's scope or to articulate clearer limits on the government speech doctrine. However, the court's decision to deny review suggests that at least for now, there isn't sufficient interest among the justices in taking up these questions. Let's spend some time considering the various perspectives on this issue, because this isn't a simple case where one side is obviously right and the other obviously wrong. There are legitimate concerns and valid arguments on multiple sides. From the government's perspective, there are real interests at stake. License plates are government-issued identification documents. They appear on government property, the vehicles themselves being registered and regulated by the state. The plates bear state seals, state names, and official design elements. When the general public sees a license plate, they know it's been issued by the government. If offensive, vulgar, or hateful messages appear on plates, some members of the public may associate those messages with government approval or endorsement. The government has an interest in maintaining the dignity and appropriateness of official state documents. Additionally, government employees shouldn't have to be in the business of issuing plates with racist slurs, explicit sexual content, or messages promoting violence. There's something to be said for allowing the government to set basic standards of decency for its own documents. From the free speech advocate's perspective, the concerns are equally compelling. The whole point of a vanity plate program is to allow individuals to express themselves. People pay extra money precisely because they want to communicate something personal, whether it's their name, their profession, their hobbies, their sense of humor, or their values. When the government creates such a program and then uses vague standards like offensive to good taste to pick and choose which expressions to allow, that's viewpoint discrimination. The fact that enforcement is so inconsistent and selective only makes it worse. And there's a real slippery slope concern here. If vanity plates are government speech, what else might be classified that way? Could the government claim that internet domain registrations are government speech? Business licenses? Professional certifications? The more we expand the government speech doctrine, the more we shrink the space for genuine private expression. From a practical citizen's standpoint, many people would probably say they don't think of vanity plates as government messages at all. When you see a plate that says LUVBUGS or DOCTOR or GOBIG, you don't think the state is expressing love for insects, identifying someone's profession, or cheering for a sports team. You think the vehicle owner is expressing something about themselves. The intuitive public understanding seems to align more with the private speech characterization than the government speech characterization. Of course, public perception is just one factor in the legal analysis, but it's not an irrelevant one. From a legal consistency perspective, there's a strong argument that the distinction between specialty plates and vanity plates matters. Specialty plates involve the government curating and approving specific designs that become officially available options. That's much more like government endorsement. Vanity plates involve individuals creating unique combinations that the government simply reviews for compliance with general standards. That's much more like a limited forum for individual expression. Treating these two categories identically may not make sense doctrinally. Now let's think about the impacts of this decision in several different domains. For individual vehicle owners, the impact is direct. People in Tennessee and other states with similar rules will continue to face the possibility that plates they've had for years could be revoked based on a single complaint and a bureaucrat's subjective interpretation of what's offensive. There's no meaningful due process, no clear standards, and no protection against arbitrary enforcement. Vehicle owners who want to express themselves through their plates will need to self-censor, choosing safe, bland messages rather than risking rejection or revocation. For free speech jurisprudence more broadly, this is a missed opportunity for the Supreme Court to provide guidance on an area of law that's becoming increasingly muddled. The government speech doctrine is being invoked more frequently in more contexts. Without clear boundaries and limiting principles, there's a risk that it will swallow up significant areas of private expression. Lower courts are struggling with these issues and they would benefit from Supreme Court direction. For the administrative state and government discretion, the decision reinforces the ability of government agencies to exercise broad, largely unreviewable authority in certain contexts. If an agency can classify something as government speech, it can avoid First Amendment scrutiny entirely. This may be efficient from a governance perspective, but it's concerning from a civil liberties perspective. Unchecked discretion is always dangerous, even when exercised by well-meaning officials. For cultural expression and identity, vanity plates may seem trivial, but they're one of the few ways that people can customize something that's otherwise standardized and government-controlled. For some people, their plate is a meaningful expression of who they are. Gaming culture, astronomy enthusiasm, humor, linguistic creativity, all of these are forms of cultural expression. When the government can suppress these expressions based on vague notions of taste and decency, it's not just regulating license plates. It's regulating culture and identity. For political and social movements, the implications extend beyond individual expression. Historically, license plates have been sites of political and ideological contestation. Remember the Woolley versus Maynard case from 1977, where Jehovah's Witnesses in New Hampshire objected to displaying the state motto "Live Free or Die" because it conflicted with their religious beliefs. The Supreme Court held that the state couldn't force them to display that message. That was a compelled speech case, but it illustrates how license plates can become battlegrounds for constitutional rights. If vanity plates are government speech, the government could potentially prohibit political messages it disagrees with, slogans associated with particular movements, or expressions of dissent. The potential for abuse is significant. For interstate commerce and mobility, the patchwork of different state rules creates practical problems. People move between states for work, education, military service, and family reasons. Having your constitutionally protected expression rights change based on which state you're in is problematic. It's similar to the issues that arise with gun rights, where what's legal in one state may be criminal in another. Federal constitutional rights shouldn't be so geographically variable. Let's also consider what this means for the legal profession and civil rights litigation. Lawyers like Daniel Horwitz, who represents Gilliam, invest significant time and resources in cases like this. They do so because they believe fundamental rights are at stake. When the Supreme Court declines review, it can be discouraging for civil rights advocates. But it doesn't mean the fight is over. Cases can be brought in other circuits, creating different precedents and potentially creating circuit splits that the Supreme Court will eventually have to resolve. The legal community will continue to debate and litigate these issues. From a legislative perspective, states could choose to address these concerns through clearer statutes. Instead of vague standards like offensive to good taste, states could adopt more specific, objective criteria. They could prohibit plates containing common profanities, plates that incite violence, plates containing racial or ethnic slurs, plates with explicit sexual content, and so on. These would still be content-based restrictions, but they would be more predictable and less susceptible to selective enforcement. However, even with clearer standards, the fundamental question of whether vanity plates are government or private speech would remain. Another option for reform would be to eliminate vanity plate programs entirely, as one Utah legislator proposed. If states find it too difficult to regulate content in a constitutionally acceptable manner, they could simply stop offering personalized plates. But that seems like an extreme response that punishes the vast majority of people who use vanity plates responsibly in order to avoid difficult constitutional questions. It's a solution, but it's not a particularly good one. Alternatively, states could adopt a much more permissive approach, allowing virtually anything on vanity plates with very few restrictions. This would treat plates more clearly as private speech and would minimize government discretion. The downside is that you would inevitably see more plates that many people find offensive, vulgar, or hateful. But as Justice Harlan wrote in Cohen v. California, one man's vulgarity is another man's lyric. A free society has to tolerate some speech that offends us. That's the price of living in a democracy with robust free speech protections. Let's turn to some hypothetical scenarios to illustrate the practical implications. Imagine someone wants a plate that says THINBLUE to express support for law enforcement. In some communities, this would be welcomed. In others, particularly in the wake of controversies over police conduct, it might be seen as provocative or offensive. Should the government be able to deny that plate? Under the government speech doctrine, yes. The government could decide it doesn't want to be seen as taking sides on controversial issues related to policing. Or imagine someone wants a plate that says LOVEWINS to celebrate marriage equality. Depending on the politics and demographics of a state, this might be denied as offensive to some people's religious beliefs or values. Again, under the government speech doctrine, the state could make that determination. But many people would see that as viewpoint discrimination against LGBTQ individuals. Consider a plate that says RESIST, which became a popular slogan during certain political administrations. Is that government speech? Is the government expressing resistance to itself? The absurdity becomes apparent. Of course, the plate holder is expressing resistance or dissent, not the government. Yet if vanity plates are government speech, the government could prohibit this message. Or think about plates expressing views on controversial issues like FREEDOM or JUSTIC or EQUALITY. These are terms with political valence. Different people interpret them in different ways. Should the government be able to pick and choose which interpretations to allow? The point of running through these hypotheticals is to illustrate that the government speech classification leads to troubling outcomes when applied to vanity plates. It gives government officials enormous power to suppress expression based on whether they personally agree with or approve of the message. That's not how the First Amendment is supposed to work. Now, some defenders of the government speech approach would say that vehicle owners have other options for expression. You can put bumper stickers on your car. You can hang things from your rearview mirror. You can paint your vehicle. These are all forms of private expression that the government can't restrict. This is essentially what Justice Breyer said in Walker when he wrote that vehicle owners could simply display their desired message on a bumper sticker right next to the plate. But this argument misses something important. Vanity plates are distinctive precisely because they're part of the official license plate. They have a legitimacy and visibility that bumper stickers lack. People choose vanity plates over bumper stickers for a reason. Saying you can express yourself some other way doesn't fully address the constitutional concern. There's also an argument about resources and administrative burden. If vanity plates are treated as private speech subject to viewpoint-neutral restrictions, states might face more litigation. Every time a plate is denied, the vehicle owner could potentially sue, claiming viewpoint discrimination. States would have to defend their decisions in court, justify their standards, prove viewpoint neutrality. That's expensive and time-consuming. The government speech doctrine avoids these costs by simply saying the First Amendment doesn't apply. From an efficiency standpoint, that's appealing. But constitutional rights aren't about efficiency. They're about protecting individual liberty even when it's inconvenient for the government. Let me address one more dimension of this case that we haven't fully explored yet: the role of technology and changing communication norms. When license plates were first introduced over a century ago, they were purely identificatory. A random series of numbers and letters to track vehicle registration. Over time, states added decorative elements, slogans, symbols. But these were all government-chosen. The vanity plate is a more recent innovation, made possible by computer databases that can track customized plates. And as technology has evolved, so has our culture of personal expression. We live in an era of social media, personal branding, curated online identities. People are accustomed to expressing themselves publicly in myriad ways. Vanity plates are part of that broader cultural shift toward personalization and individual expression. Legal doctrines developed in earlier eras may need to be reconsidered in light of these changed circumstances. As we approach the conclusion of our analysis, let's synthesize what we've learned. The Supreme Court's decision to decline review of Gilliam's case leaves us with significant uncertainty and inconsistency in this area of law. Tennessee can continue to enforce its rules, and Gilliam will not get her plate back. But vehicle owners in other states may have more protection, depending on how their state courts have interpreted Walker and its application to vanity plates. The fundamental tension between the government speech doctrine and individual expressive freedom remains unresolved. The broader implications extend beyond license plates to questions about how we balance government authority with individual liberty, how we define the boundaries of government speech, and how we ensure that constitutional rights have meaningful content and aren't eroded through expansive interpretations of government power. These are enduring questions in constitutional law, and they don't have easy answers. For students of constitutional law, this case is a valuable reminder that First Amendment doctrine is still developing and contested. The government speech doctrine is relatively young in constitutional terms. Its contours are still being defined. Lower courts disagree about how to apply it. The Supreme Court has not provided comprehensive guidance. This uncertainty creates both opportunities and risks. Opportunities for creative lawyering, for developing new arguments and theories, for persuading courts to adopt better interpretations. Risks for individuals whose rights may be inadequately protected during this period of doctrinal uncertainty. For citizens more broadly, the lesson is that constitutional rights require constant vigilance. Rights that seem secure can be eroded through incremental expansions of government power, through doctrines that sound reasonable in the abstract but lead to troubling results in application. Paying attention to cases like Gilliam's, even when they seem to involve relatively minor issues like license plates, helps us understand how our freedoms are protected or threatened in everyday contexts. Looking forward, several things could happen. First, the issue could percolate in lower courts for several more years until a clearer circuit split emerges or until a case with particularly compelling facts comes along that persuades the Supreme Court to grant review. Second, states could voluntarily reform their statutes and procedures to provide more clarity and reduce arbitrary enforcement. Third, public pressure and media attention could influence how these cases are decided and how government officials exercise their discretion. Fourth, other forms of government-facilitated expression could come under scrutiny, with parties on both sides invoking either Walker or distinguishing it, gradually developing a more nuanced framework. The story of Leah Gilliam and her license plate may seem like a quirky footnote in constitutional history, but it represents something more significant. It represents an individual standing up for her right to express herself, even when that expression is unconventional or potentially controversial. It represents the ongoing struggle to define the proper limits of government power in a free society. And it represents the reality that our constitutional freedoms are not abstract principles but lived experiences that affect real people in concrete ways. Whether you agree with Gilliam's position or with Tennessee's position, whether you think vanity plates should be considered government speech or private speech, the case forces us to think carefully about what free speech means in the modern administrative state. It challenges us to consider whether our constitutional doctrines adequately protect expressive freedom or whether they give too much deference to government discretion. And it reminds us that seemingly small cases can raise profound questions about liberty, authority, and the relationship between citizen and state. As we conclude, I want you to think about your own views on these questions. If you had to decide this case, how would you rule? Do you think Gilliam should be able to keep her plate? Do you think Tennessee's concerns are legitimate? How would you balance the competing interests at stake? These aren't easy questions, and reasonable people can disagree. But they're important questions that go to the heart of what it means to live in a constitutional democracy. The Supreme Court's decision today not to hear this case doesn't resolve these questions. It simply leaves them for another day, another case, another time. In the meantime, people like Leah Gilliam will continue to fight for their rights. Lawyers and advocates will continue to develop arguments and strategies. Courts will continue to grapple with how to apply constitutional principles to new and changing circumstances. And all of us, as citizens, will continue to navigate a legal landscape where our rights are both protected and contested, both affirmed and challenged. Thank you for your attention over these past 90 minutes. I hope this analysis has given you a deeper understanding of the case, the constitutional issues at stake, and the broader implications for free speech in America. The conversation doesn't end here. It continues in courtrooms, in legislatures, in public discourse, and in each of our daily lives as we exercise and defend our fundamental freedoms.